We are delighted that you are here. Welcome to UCL, welcome to London. Professor Maria Lee and I teach on the environmental law modules on the LLM. And so some of you, the very lucky bunch of you, will be seeing us during the course of this year. We'll do further introductions in a second, but do something for me before we begin. Everyone take a deep breath. What was in that breath you just took in then? What pollutants were in that breath? What harmful substances have just gone into your lungs from the very fact of you being here in London? That's what we're going to talk to you about today, about air pollution, air quality standards, about litigation in relation to air quality, and about the role of lawyers in relation to that litigation. So I'll let Maria introduce herself.
Hello, I'm always very excited at this time of year. I think I revert to childhood in some way. It's the start of a new year, new people, new things to learn. So I'm very much looking forward to meeting many of you as we go through the year. I work primarily in environmental law, also in tort law. So I'll be meeting all of you that are taking any environmental law courses, and some of you are also taking our course on regulation and tort, so I will be seeing you as well. You'll get lots of opportunities through the year to learn about my research and Stephen's research. That's the last time you're going to see me in shorts.
I'm Stephen Vaughan. I began my life as a corporate finance lawyer doing the sort of things that Graham was just talking to you about. And then I thought to myself, life's too short, go and do something else. And so I went off and did a PhD and became an academic. And I was an environmental lawyer when I was in practice, but a sort of evil environmental lawyer. And I'll come back to that later on.
Okay, so those of you, I can't find the... Yes, those of you that are taking environmental law this year, you are very welcome members of the Centre for Law and the Environment. We have a very lively Centre for Law and the Environment at UCL. We have lots of events, many of which are particularly for students, and lots of research and activity within the centre. So you're all very welcome. Follow us on Twitter to see what we're doing. Sign up right now. And I am going to take a photo of you before I go and tweet it. So if you don't want to be seen, I don't know, do something. You are, everyone, whatever courses you're taking, you're welcome at Andy Sterling's lecture on the 31st of October. He is a fabulous speaker and a fabulous scholar. And there are drinks afterwards. And it's early in the year. So it's a great opportunity for you to come along and get to know each other. Okay, over a drink, and us, of course. Similarly, evidence, publics and decision-making, major wind infrastructure, that's a project that I've been involved in over the last 2.5 years. It's our final event. You're very welcome. The Policy and Practice Away Day, in the first instance, is just for environmental law students. So environmental law students, even if you're only doing one course, you can sign up first. If there are any spaces left, we will open it up. It'll be a great day. We have lots of really fascinating people who are in touch with the centre, honorary and visiting members of the centre, who will talk to you about their practice. Okay, so it's a great day. Gives you a perspective that we don't, that we can't really. Okay, so Centre for Law and the Environment, you're very welcome, and I'm looking forward to seeing many of you at our events through the year. Let's move on to air pollution and law. The EU Air Quality Directive. Anyone who doesn't know what an EU directive is needs to go to Lucinda Miller's lecture on Thursday, when she will be introducing the European Union to non-EU students. For now, what you need to know is that EU legislation is binding on all 28 members of the European Union, currently including the United Kingdom. So if you're studying in Europe, or indeed most places, you cannot avoid EU law. Now is a wonderful opportunity to get to know it if you don't already. The Air Quality Directive and the 2008 Directive is essentially a recast, a rearrangement, not new standards, of a 2003 Directive, so it's older. Article 13, limits for nitrogen dioxide. The limit provided may not be exceeded from the 1st of January 2010. Article 23, Every member state has to prepare an air quality plan explaining how they will meet that target and how they will continue to comply with that target. And if they have breached that target, how they will come into compliance in as short a period as possible. Okay, now, guess what? The UK did not comply with that. Everyone agreed that we were not compliant with that provision. Nitrogen dioxide is our primary concern, and we breached the nitrogen dioxide issue, the nitrogen dioxide limit. ClientEarth, an environmental NGO which Stephen will be coming back to, decided to judicially review the UK government's failure to comply. Agreed facts, the limits were breached. Agreed facts, nitrogen dioxide can irritate the eyes, nose, throat and lungs. It leads to coughing, shortness of breath, tiredness, nausea. It has a long-term impact on lung function and respiratory system. Nitrogen dioxide is one component of particulate matter. Particulate matter creates the equivalent of 29,000 premature deaths in the United Kingdom every year. Those facts were agreed between ClientEarth and the government. Okay, so the government agreed they breached, and that was the impact, 29,000 deaths a year. High Court decision. If you don't know what the High Court is, go to Julius Grower's lecture on the English legal system on Thursday. He will talk you through the court system. This is our first instant court. Judicial review, the primary remedy would be a declaration declaring that the government is in breach. The High Court said, we're not going to grant a declaration because the government already admits it's in breach, so what's the point? So no declaration, no remedy. The High Court was concerned about the serious political and economic questions raised by enforcing the Article 13 obligation. Views in this room will differ on the correctness of that. The wording of Article 13 has a hard edge. It says you shall comply by 2010. We weren't in compliance. The court inferred discretion into that obligation and said government decides. Court of Appeal was similar. Then we get to the Supreme Court. The Supreme Court, under a provision of EU law that's very familiar and very traditional, which you'll learn about on Thursday, the Supreme Court asked the Court of Justice of the European Union to provide an interpretation of the EU law. Okay, to provide an interpretation of the Air Quality Directive. And in the course of that interpretation, the Court of Justice emphasised the obligation on national courts to take any necessary measure to ensure compliance with EU legislation. That's not new. The Supreme Court, let me say, knew that, but they wanted to hear it before they did anything. They knew that piece of law. It's been in place since the 1960s, 1970s. There was no doubt. But the Supreme Court felt comfortable asking the Court of Justice to give them this ruling. The Supreme Court granted a declaration. The Supreme Court saw some value in a formal statement of the legal position. Okay? So unlike the Court of Appeal and the High Court, a value in declaring the government to be in breach. More interesting, the Supreme Court granted a mandatory order, very unusual, against the government, telling them to come up with a plan that complies with Article 23. Okay, so the Supreme Court required the government to come up with a plan that complied with Article 23. Back to court. The government came up with a plan. ClientEarth said that doesn't comply with Article 23. Basically, the plan was pretty much business as usual. We'd comply with EU air quality legislation sometime by 2030, if we were lucky. Is that an exceedance period as short as possible? The High Court said no. The High Court said this plan breaches Article 23. The government enjoys discretion in how it complies with its air quality obligations, but that discretion is narrow and greatly constrained. Government was giving disproportionate weight to considerations of cost, political sensitivity, administrative difficulties. Again, views will differ. What's the role of the court here to say, actually, air quality is more important than schools and hospitals? Okay, because that was the government's position. Okay, how much discretion should the courts leave governments when the law is clear? You know, the government took on this obligation. This case I won't talk about. It was an unsuccessful challenge by ClientEarth to the consultation on the new air quality management plan. There is now a plan, and look, we'll have draft plans by March 2018. The final plans are due about this time next year. Okay? In 2018, we'll have a plan to comply with an obligation that should have been met in 2010, which was initially set in 2003. Okay, so if we're thinking about the power of law, there's a problem here. Is this a story of success or failure? Well, in one respect, this is law failing. You know, we have not got clean air. Okay, and London is one of the most problematic cities in the UK. From the perspective of ClientEarth, this is an enormous success. And you might also say this demonstrates that law matters, because without those obligations to create air quality management plans, we wouldn't even be thinking 2018, we'd be thinking 2030 at the earliest. 2030 is meaningless in this context. So there's a real dilemma here. Is this law working or law failing? I don't know what the answer to that question is, but it's the sort of thing we want to think about on this course. What is the role of law in responding to environmental problems? I won't say too much about Brexit, because those of you who are taking environmental law will hear far too much from me about Brexit. But forget the standards. Let's assume that the NGOs would fight really hard if government tried to lower the standards. Let's think about enforcement and accountability. It was the EU element of the litigation that allowed the court to require a remedy. My fear for Brexit is not that the standards will lower, it's that we lose those accountability mechanisms. Those of you who are taking our courses will hear more about that. I shall now hand over to Stephen.
Thank you, Maria. So I'm going to talk to you about lawyers as environmental actors. And the reason I'm going to do that is because my research breaks down into two groups. So I'm interested both in environmental law and in lawyers' ethics. So I'm going to step back from the case law and talk to you about the ways in which lawyers were involved in those cases in regulation and enforcement. I take a very Socratic approach to my teaching, which means that I'm going to pick on you and ask you some questions. So, in what ways do you think lawyers are relevant to clean air regulation and enforcement? So I'll look for volunteers first. What are lawyers doing in this space?
Class actions?
Yep, so they're bringing class actions, so lawyers are acting on behalf of large groups, challenging the laws, seeking to enforce them. Yeah, what else is going on? So let's think of them as the good lawyers. Yep, thank you. So the government lawyers are drafting legislation. They're the ones advising the government, so helping to transpose, for example, EU law. What else is going on? What about lawyers like Graham, who was speaking to you earlier? What are lawyers in large law firms doing?
Advising them so they can get around regulation.
Yeah, that's certainly one way of framing. I couldn't possibly comment. So maybe they're advising them to get round law. Maybe they're just telling them what the law is, helping them to comply. So we see lawyers everywhere, and thank you for those answers. It's like I'd plugged you into the audience, because these are the three things that I think we see lawyers doing. They act as lobbyists. They help their clients to draft and frame primary and secondary legislation. They act as legislators. So they say to their clients, this is what we think the law means. They then try and persuade the courts, this is what we think the law means. And if the courts and their clients accept those definitions, they then become norms that are accepted. And they act as litigators, so bringing claims. And we see these lawyers everywhere, as we've already been talking about. And we think about the ClientEarth litigation, we would have the government lawyers doing the legislation, advising the government. And imagine you're a government lawyer at this point, and you know the government is in breach. And you, because you're a good person, you're giving your life to public service, are having to advise a client that you know is in breach of some rules and regulations that are causing 29,000 deaths. How does that make you feel? Would you all be happy doing that? Getting paid? Would anyone have an issue with that? Are you all here doing corporate finance? I see what you're doing. Then we have the lawyers who act for large organizations, the in-house lawyers who are talking to their clients, advising the businesses. We have the lawyers in the large law firms and the lawyers in ClientEarth. So my research, the kind of focus of my lawyers' ethics research is on what lawyers are doing, so the norms and the principles that shape their practices. And as a field of study, lawyers' ethics has been around for 5 decades. And what we're really asking is this question that the American jurist Charles Fried put up, which is, can a good lawyer be a good person? And the 3 basic answers are yes, no, and maybe. And I say to my students when I teach lawyers' ethics, would you like a murderer as a friend? And hopefully most of them say, no, probably not. And then I say, would you be willing to defend a murderer? And most of them say yes. And that's really what lawyers' ethics is about. There is something special to the role of the lawyer, something about role morality when you inhabit the space of being the lawyer that changes your views, perhaps what you're willing to do or not do. So when we talk about lawyers' ethics, we often talk about this standard conception. So this is what most people believe lawyers should be doing. So lots of American and Southeast Asian jurists kind of take this approach. So it's made up of 3 principles. First one is neutrality. It's not for the lawyer to judge their client. I can work for the government even though they're causing 29,000 deaths because it's not my job to judge them. I can work for BP. It's not my job to judge them. Equally, non-accountability. Me acting for the government, me acting for BP, you shouldn't tarnish me with their brush. I should be able to go home at the end of the day, have my shower, and forget about those 29,000 deaths. And then finally, partisanship is the idea that the law exists, and simply lawyers in lawyering are mechanics, they are technicians. They are there to effectuate their clients' wishes within the bounds of the law. And as the gentleman said at the back, if the law has a grey space, if there is a loophole, then shouldn't I be exploiting that for my client's interests? If the grey space exists, that's the fault of the court, that's the fault of the government, not my client's fault. So let me kind of bring this back to air pollution and environmental law. So in almost every jurisdiction, there is a sense that lawyers have a public interest obligation. They stand between the state and their client. So the lawyers kind of sit in this middle space. They protect their client from the state, but also what they're meant to do is to keep their clients from doing wrong, from kind of taking illegal acts, from using the law for nefarious purposes. This public interest idea. And one of the things I'm interested in is, does this extend to environmental issues? So is there a public interest in a healthy environment? And if there is, does that mean that lawyers should be pursuing a healthy environment via their public interest obligations? So if I'm the lawyer for the government, if I'm the lawyer for BP, should I be saying to my client, should we really be doing this? Should I be having that moral dialogue with my client? So let's have a show of hands. Who do you think, which of you think that moral dialogue is important? Hands up. You're looking around thinking, am I amoral by not saying this? And those of you who think you shouldn't be having that moral dialogue? I know more of you are thinking it really. What might be your concerns if you're engaging in a moral dialogue with your client? So you've got the CEO of BP in front of you. Sorry, where was the hand? Oh, sorry, thank you. Yep, so you might be worried about the consequences, yep, certainly. You might have a house, you might want to pay your bills, you might have a family, you might be worried about the client never coming back to you. So the reason I left practice is that I was asked to do tobacco litigation, and I just couldn't bring myself to do it. And I said to my boss, I cannot do this, I cannot act for tobacco companies. And he said, everyone has the right to a lawyer. And I said, yeah, but not me. I don't want to be their lawyer. And it's a very personal question. This is why I think lawyers' ethics are so interesting. We have these personal struggles that are going on. And for ClientEarth, for the organization that Maria was talking about, the NGO, they are at one end perhaps of a spectrum. So they are bringing these cases, who is the client in ClientEarth? It's not a trick question. It's the earth. They're bringing these cases on behalf of the environment because they believe that there is a right to a healthy environment, because they believe these things are important. So Anna Heslop, one of the lawyers from ClientEarth, says, it is a privilege to be able to take action which protects and enhances the environment. I think that's great, but I also think the earth doesn't really exist. It can't give Anna instructions. The earth didn't come knocking on Anna's door and say, please litigate against the government. Equally, if we look at this quote from another ClientEarth lawyer, from Alan Andrews, we believe everyone has the right to breathe clean air, and so took the UK government to court over air pollution with one lawyer and one. And that's great, and I think, wow, that's really impressive. But I also might think, and we might have divided views on this, that actually I want there to be hospitals that I can go to with doctors who will be able to treat me. And I want there to be schools for my nieces to go to that have vaguely acceptable standards. I didn't ask ClientEarth to do this on my behalf. And so while these things, these actions against the government might have very positive consequences, we might ask about the role of these lawyers and what they're doing. And we tend to think about these sorts of actions, these sorts of NGOs, as cause lawyering. So these lawyers have a particular cause. They want to protect the environment. They want to promote equal marriage. You can have conservative causes, the right to bear arms, abortion. And these lawyers are acting on behalf of the cause. They see the cause as, sometimes, more important than any individual client. And the question then becomes, people who study these lawyers, is that right? When should they be allowed to take actions that are deleterious, that go against the kind of best interests of their client because they're trying to pursue the cause? And there's no kind of clear-cut answer to that. So let me give you a scenario that we'll end with. So you're the director of an environmental NGO, and I have to say, by the way, this is Maria's scenario, which I have just stolen for today. You are the director of an environmental NGO with a strong legal team. You have two cases in mind. So you have to choose one of these. Case one, an action against some carbon majors, so large corporates, in respect of sea level rise and associated coastal erosion and property damage. This will involve identifying and approaching individuals who've suffered property damage. So your lawyers tell you the case will be radical, but with some chance of success. Case two, judicial review against the government for failure to implement the Climate Change Act. Your lawyers tell you you have a decent chance of success, but government will fight hard, and there are some difficult questions to be resolved. Of these two cases, which do you think is more likely to get front page headlines? One or two? A little bit of a divide. Why do we think two, those who said two? Which is more global, do you think? One might be more global. Which is sexier? So imagine you're writing the headline. Imagine you're the newspaper journalist writing the headline. Failure to comply with the Climate Change Act. People fleeing homes. Which of the headlines is more interesting? Which is more likely to win? Should you pursue the case that you think is least likely to win if you think it will get you more political coverage, it will get you more media coverage, it will make your NGO better known? Which one should you be doing? And they're the sorts of questions that I'm interested in, the questions that we can ask about cases like ClientEarth. So, do you have any questions?
Sarah tells me we don't have
there'll be no time for questions. We've been
Well,
too interesting for
we'll
you.
be here all year, so you can ask us any questions all year. There's one thing that I just want to add. First of all, both Anna and Alan have taken modules on this LLM. Secondly, UCL Use, the University College of London Union's BME group, are running an environmental justice project which focuses on air pollution, but essentially is about going into schools and raising awareness about environmental and sustainability issues, and most importantly, linking that with political action. So talking to school children about the environment and political action. They do need a bit of legal help, so if any of you are interested in that project, I will send a link round to the environmental law students once Moodle is up and running at the end of the week. Anyone who isn't taking one of my courses who's interested, drop me an email and I can send you details. Okay?
And as you take deep breaths, think about us today.